This is one of those courtroom cases where everything that could go wrong absolutely does. Today we're looking at a defendant who walks into court convinced he's playing chess, when in reality, he's barely on the board. Meet Don Lyons, a man representing himself, leaning heavily on special appearances, jurisdiction challenges, and paperwork that sounds impressive, but collapses the moment it meets actual law. Now here's the twist. This isn't just one hearing, this is a series of appearances, and each one builds toward a courtroom disaster that you can see coming from a mile away. Except he can't. From requesting continuances to filing motions that don't meet legal standards, to ultimately standing trial completely unprepared, this case is a masterclass in what happens when confidence replaces competence. And wait until you see the trial. No real cross-examination, no strategy, no evidence presented, just missed opportunities stacked on top of each other until the outcome becomes inevitable. The judge even warns him about the risks of going pro se, and he still pushes forward. So here's the question for you watching. If you were in his position, would you trust yourself to navigate criminal law alone? Or would you realize early on that this system has rules for a reason? Because by the end of this video, you're going to see exactly how fast things unravel when those rules are ignored, and why this case ends the way it does.
December 22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346. State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed one additional charge. It's for count 3 operating vehicle with an ACE of 0.15 or more. The state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500 of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yeah, so that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today, but what we'll do is we'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that, say January 26th at 9:30.
What date is that?
January 26th.
What's that date? Whoa. No,
Okay, we're going to do the 28th.
Yeah, 28th.
Okay,
Let's pause right here, because what you're seeing is a very common, but very misunderstood strategy. When Don Lyons says he's making a special appearance in challenging jurisdiction, he likely believes this gives him some kind of legal advantage. But in reality, in a standard criminal court, this doesn't work the way he thinks it does. Automatically have jurisdiction over criminal matters that occur within their geographic area. So unless there's a very specific legal defect, simply saying I don't recognize your authority doesn't change anything. And notice the judge's response, calm, direct, and completely unmoved. That's because these arguments have been seen countless times before. What's more important here is what isn't happening. Instead of focusing on building a defense, reviewing evidence, or negotiating with the prosecution, he's spending time on arguments that won't hold up. And that's a critical mistake. So let me ask you, do you think he genuinely believes this strategy will work? Or is this more about misunderstanding how the legal system actually operates?
I had wrote an affidavit, and I'm still waiting for a response.
Okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look too. Doesn't make any specific requests. It's a request for dismissal of charges, and this does not comply with Criminal Rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial.
Uh,
Set that April 1st at 1:30. So that's going to be the court's order for today. This will be set for a bench trial, April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
April 1st, what time?
1:30 p.m., sir.
Now, this is where things start to get serious. The judge clearly explains that representing yourself means you're held to the same standard as an attorney. That includes understanding rules of evidence, procedure, and how to properly file motions. And here's the problem. Don Lyons agrees to move forward anyway. His affidavit, which he likely believes is a strong legal document, doesn't meet the requirements of a proper motion. The judge even points out that it doesn't comply with procedural rules. That's not a minor technicality. That's the difference between being heard and being ignored in court. This moment is crucial because it sets the stage for what's coming next. A trial where preparation, legal knowledge, and strategy matter more than anything. So think about it. If you were told you'd be judged by the same standards as a trained lawyer, would you still go forward alone?
It's come and gone. Today we're set for a trial on the facts that matter. So if you have issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh.
Any questions, Mr. Lyons?
Yes. You, what side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side,
Smelled alcohol on the passenger side and on the driver's side.
but she was on the passenger side first, right? When you said it, right?
Yeah.
Alright. So when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. I got him supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file?
So you have to ask questions about it.
So you don't know if it's on file or not.
They have all my body camera, dash camera,
You don't know.
all that. I sent it to them, so I would assume so.
You said the warrant was signed around 6:21.
Well, it was around 6:21, so I'd read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I can't see it. And I see it. But I really don't recall. And if there was a warrant, you know what I'm saying?
It was
go about it like that. But
Part
I
of
don't
course,
recall it no more.
One.
I
Sure
would
to say that.
feel
Give it a
I was,
question.
I feel like I was on I do, but not right, not at the moment.
Anything up that state?
No, you're.
You can step down, sir.
Thanks, sir.
And y'all didn't give me the motion of discovery. I was thinking y'all was gonna send it to me. I didn't know I had to buy for it. That's my ignorance. I don't have no evidence. No, sir.
So
Today's trial, the state needed to prove, carry their burden, need to prove beyond a reasonable doubt. On count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing.
Mr. Lyons, is there anything you'd like me to consider on sentencing?
I mean, my grand got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. What they were presented, that'd be nice.
Any on sentencing state?
Just a few questions, Your Honor.
What you just witnessed is the turning point of the entire case. And honestly, it's painful to watch. This is cross-examination, one of the most powerful tools a defense has, and it's completely wasted. Instead of challenging probable cause, questioning inconsistencies, or probing the reliability of the evidence, he focuses almost entirely on whether he remembers a warrant being read to him while intoxicated. That's not a strong legal strategy. That's a distraction from the core issues. And it gets worse. When the nurse and lab technician testify, two key witnesses, he barely asks anything at all. No challenges, no follow-ups, no attempt to create doubt. In a criminal trial, silence like this can be devastating, because unchallenged testimony is often accepted as fact. A trained attorney would be looking for cracks, procedural errors, timing issues, chain of custody problems. But here, nothing. So let me ask you, at this point, do you think there's any realistic path left for him to win this case?
Is any other evidence from the state?
No,
What's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understandably, if I would put you on probation, it'd be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today.
And just like that, the outcome becomes inevitable. The court finds Don Lyons guilty, not because of bias, not because of unfair treatment, but because the evidence presented by the state went completely unchallenged. In criminal law, the burden is beyond a reasonable doubt, and when the defense doesn't introduce doubt, the result speaks for itself. The sentencing is actually more restrained than it could have been. Just a few days in jail, court costs, and a license suspension. But even then, you can see the reality hit when he brings up personal responsibilities at the very last moment. And the judge's response is blunt but fair. You knew this day was coming. This case highlights a bigger lesson. Confidence in court is not a substitute for legal knowledge. Representing yourself isn't just risky, it can completely shape the outcome of your case. So what do you think? Was this avoidable? Could this have gone differently with proper legal representation? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.